Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
We're back. Welcome to the afternoon's fresh hell. We are in the Zoom room waiting for the hearing to start. We're supposed to be in courtroom 25, right? Boots on the ground? Anyone? For the Myles King / Brian Walshe. I don't know. I'm confused because it says this morning at 9 a.m. there was a conference on Walshe in front of Krupp for status, but I don't know if they didn't update the calendar. Then I've got Myles King, Bianca Chinocchio, Giovanni De Los Santos, Sean Johnson, and Michael Campbell. All of those cases on at 2 p.m. with Krupp in courtroom 25. And it looks like it's the only case on for 2 p.m. So I know that I think Lamassouz at least was going over there for this, except for I've got my Zoom says that I'm in the main session, which I think it's supposed to say quorum 25, but we will wait. And here we are. The other good news is that I got the audio from yesterday's Brian Walshe hearing where the judge committed him to Bridgewater State Hospital. We will listen to that after this. So I have that audio that I ordered. It's only about 15 minutes long. So we'll listen to that after this hearing. Okay? All right. Hold, please. Did anyone bring brownies? I don't know. Cupcakes. I don't know. Cindy has pets became a new member. Welcome, Cindy. And I also have Karen Reed's attorney's papers in opposition to the newly filed motion by Cosgrove to get a taint team to look at her phones that they've had since January of 2024. So, there's that. How you doing, folks? How you doing out there? How you doing? Let's take a look and see if anything happened on Brian Walshe this morning, because I'm confused. But, I mean, is there ever a day when we're not confused over here? Like, did Krupp hear that case this morning when Brian Walshe has just been sent over to Bridgewater State? Let's see. Looks like, sounds like. It didn't say anything. It doesn't say whether it was held or not. So, here we sit, confused as usual. But, same day, same thing, different day in Norfolk County. or no, fuck the county. However, whatever you want to call it, I'm all right. Just don't type the word in the chat. YouTube doesn't like it. Hey, it's me. He says I'm a big Dave Matthews Band fan. Just can't get behind Taylor Swift. Please don't hate me. That's okay. That's all right. That's okay. I'm gonna like her anyway. And I'll take you 5. So thank you very much for playing. My kids like Taylor Swift, so I like Taylor Swift. It's not like I'm a, old woman who just likes Taylor Swift. It's because it's music that I've been listening to with my 3 youngest girls for many, 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 many years. That it's music that I would allow to be played in the car. Unlike, Cardi B, which I didn't really know much about Cardi B until we handed her to trial, and I just think she's funny. So that's where I'm coming from. So there's that. This is on Zoom. I'll pull up the Zoom screen so people don't start getting all antsy that it's not up here. Here you go. We're waiting. Waiting for our leader. We are waiting for our leader to come in, and then we're going to see it on Zoom, and it'll be terrible angles for everyone because the only people who care about listening to this case are all here right now with me waiting on the Zoom room. All of you are here. I don't think there's a camera in the courthouse today, but I don't understand why this says main session. It's supposed to say quorum 25, but hold on. Let me just try one more thing. I'm going to see what happens if I send into like the main courtroom. Is anybody there? Oh, somebody actually just put a comment on the last video and said that she was in the courthouse and she said for Kelsey Fitzsimmons. Let me pull it up. Oh, please. And she said that the clerk must have been so confused because, where is it? She said, I was there wearing purple. Dorothy, her name is. The woman in charge of the Zoom call must have been so confused. She tested at least 10 times. We all listened to the recording saying that the capacity was full. Back and forth she went to get help. Then after 4 defendants' hearings, the judge announced, where is Attorney Bradel? Meaning in person. Then Bradel came on the Zoom and the judge went a bit nuts. Bradel explained how it was his understanding that it was Zoom. Everything ended. We all got up and left. We did make an impression on people because we walked all around the courthouse trying to find the exact courtroom. It was not posted. We marched around. All right, Dorothy, you go, girl. You go. So we're waiting for our leader to begin. And we will see if Judge Casper, the ghost in federal court, has agreed to allow the Norfolk County DA to turn over all of Proctor's communications that were, uncovered by the FBI during Karen Reed's persecution to these defendants, Myles King and others, because, they're relevant according to ADA Lisa Beatty. Wanted to show you. Good Citizen sent this to me, and she said I could share it with you. So nothing makes me happier than like baby pictures. So check this out. This is her 5-month-old grandbaby that she gave me permission to share. So check this out. I love baby pictures. I could look at or listen to those videos of babies laughing like all day long. Okay, look at this adorbs babe. She is blessed. I mean, look. Oh, that face. Oh, that face. And look, there's me in the background on the TV. Are you kidding me? This is Good Citizens, baby. And wait a second. Wait, because there's more. Don't go. There's more. Hold on. Hang tight. Look at this. She made her grandbaby a shirt that says, with a cupcake on it. And then she wrote on it, be good. Oh, it says, be cool, be kind, be classy. Cupcakes so sweet and sassy. Just have a good attorney. I want to eat this baby up. Oh my gosh, I love this baby so much. Look at the eyelashes on this baby. 5 months old. I miss the baby stage. I miss the baby stage so much. Good Citizen, you are blessed. Oh, isn't this the best? I am just, I'm verklempt. I'm verklempt. I love her face. I love her face. Look. Love. I don't think I could love this anymore. See, this is what makes me happy. We should just look at baby pictures all the time. The eyelashes are wild. She will never need mascara. I love it. Love it, love it, love it. Thank you so much for sharing this with me and for making her some Melanie little merch. It's just adorable. I love it so much. Thank you. That really, it makes me happy. It makes me happy to see that. All right. So we, again, are waiting for our leader. So adorable, right? Can't wait for the babies. Not that there's any rush over here, but grandchildren, I can't wait for a baby. I will be like the grandma who will babysit the most. Oh, no, thank you for sharing, girl. Oh, I am in love. I'm in love. You're blessed. She's adorable. 5 months old. And what breaks my heart about seeing those pictures, not to be Debbie Downer, wah, wah. But 5 months old is the age of Kelsey's baby that was ripped from her bosom. And now Kelsey's sitting in jail. And that is the age of Kelsey's baby at the time. So let that sink in. If you weren't already heartbroken, you might be more heartbroken now. Crime Child Addict, thank you so much for becoming a new member. And Just Joey says, finally on on vacation in Florida in July, I met a couple from Massachusetts now living in Florida. Asked their opinion about the Karen Reed case. The gentleman huffed and said cryptically, the whole damn state is corrupt. That's why we left. That's wild. That's wild, Joey. Thanks for your 10. Mike B from the 4-Room Thief says, good afternoon. Who's ready for Rosemary's reactions? Oh, I can't wait. I live for Rosemary's reactions. Are you kidding me? She's my spirit animal. How can we not love her? Let's see what fresh hell this hearing brings. Today. Thoughts? I just want to check the other Zoom room in the main court because I have a system. I have a system. All right. Because we don't want to miss a minute. It looks like it's the only hearing on for 2 p.m. Oh, please. Well, that says courtroom 1's meeting room. We're not in courtroom 1. We're in courtroom 25. So we don't want courtroom 1. So we're in the right room. We're in the right room. Okay. You never know. You never know because they try and hide. You can run, but you can't hide. Sweet Caroline is here, and she's like, I don't know how much crazy I can handle. Don't worry, because after this, I have the audio from yesterday's Brian Walshe hearing, in which Judge Freniere sent him to Bridgewater State because we were wondering what had happened, but we're going to get to listen to it together. So there's that. Dr. Trey said, I'm still shooketh from the last hearing we just listened to. I went outside in the sun, stood in the grass, and I feel no better. I went outside too, and it's really hot out. It's like almost 80 degrees here in New York. Is it cold for you guys? I don't know where you're calling in from, Dr. Trey, but it is beautiful here. Hot for the Hillside says, breaks my heart for her, meaning Kelsey. 7 months is when their little personalities start to bloom. Just cry emoji. Can't imagine that experience being ripped from a mother and a child. No, I can't either. It is heartbreaking. Let's see where we are. If we have a banner for this. There's the banner in case anybody comes in and says, what are we doing? What are we talking about? There it is. This is regarding Michael Proctor's texts. I think we looked at some papers yesterday. I don't know. All these days are blending together. from the Commonwealth, and it was an opposition to a Brian Walshe motion in lemonade regarding the fact that they think that today's going to be the day, that the text messages are turned over. And I can't wait to see what's involved there and how they relate to the Brian Walshe case. I can't wait. Okay, Willis is here. She's a realtor south of Boston. If you need to sell your house and get the hell out of Massachusetts, she's your girl. And she gifted 5 memberships. Thank you, Kay, and all of you who were gifted so randomly by the tubes of you. Welcome. Weekend at Bevy's says from Canada, just spitballing here, but wondering if Kelsey was granted the P test. No, she was not. Do they automatically test for pregnancy? They do in Canada. You mean when she was admitted to jail or the hospital? I mean, well, she was in the hospital for 53 days, so I'm sure before they did all of her surgeries, they did test for pregnancy. So is that what you're asking me? Like as a matter of being admitted? But because what they're trying to do is they're trying to get her bail conditions changed from blowing in that tube to the urine testing. But that has not been granted. Thank you for tuning in from Canada. Thank you for your super chat. Welcome all 4,321 of you. Please hit the like button on your way in. It helps the algorithm somehow, they tell me. I don't know. I'm supposed to say that, but it would be a nice thing to do. And also, if you're not subscribed, just hit the subscribe button. What are you waiting for? It's free. We're on a quest to 130,000 members, and we're about, I don't know how many away, but a little over 100 away. So that would be awesome if you would just hit the subscribe button. It's free. And Gigi's here with the silver bracelets, and she too gifted 5 memberships. Thank you so much. Hang on a minute. Thank you, Gigi, for gifting 5 memberships. And now at least we have 10. At least we have 10 new members that are here. And you're amazing. And Florence Not Nightingale got it 1. She said thank you. I know. Next Witness is here. Next Witness does some great work with compiling many LawTube reactions for the Karen retrials, and says if I wasn't depressed before all of this, if Kelsey wasn't depressed before all of this, she certainly is now missing all those baby milestones. I know. There's, I mean, could there be any worse punishment than somebody taking your infant, ripping your infant away from you based on the word of one guy who may have, I don't know, a vendetta against you or something, and without an opportunity to be heard? I mean, that's the worst part of it all, is the no opportunity to be heard. Horrific. Thanks for watching. New Hampshire Woman's here. Says, come on, kids, show Melanie a little love and smash the button. Like button. Come on, kids, show Melanie a little love and smash the button. Sometimes it does that. I don't know why it like repeats your message, because you probably didn't mean to say it twice, but if you did, you know, it's just extra. Walshe is what? Walshe is NBC 10. Hold on. Hold, please. For Brian Walshe. I mean, we're on the Zoom right now, but is it on there? I always get screwed up when I try and get it because it's only like on their website or something. They're not do it. They don't have it on YouTube. So, I mean, if somebody wants to email me the exact link to the exact video, that'd be great. Hello, New Zealand. I don't know. Can anyone point out one current case in Massachusetts that isn't being found to have the appearance of some type of shadiness? Says in Massachusetts, it's always the season of the witch. Well done. Well done. Just because Boston 10 may have a camera in the courtroom, it doesn't mean that they're live streaming it. So unless you know that they're actually live streaming it. But what I do know is that they have not started this Zoom. Because we're still waiting. There's a Talking Head song for you. Still waiting. And after this, we can listen to the audio from yesterday's Brian Walshe hearing. Here we go. Supporters blocking the interwebs again. Thank you, Dr. Trey. Or the judge screamed at everyone, or screamed at Bradel. Screamed at Bradel for, first of all, not being there in person, and then second of all, for what was it? Oh, for clogging up the phone lines. That there's a lot of public interest in the case. Anybody in the courthouse? Glamasu says she was going there. Letteros by Betteros says, I never click faster. That when next witness drops a video. That's sweet. All right. And we wait. And we wait. And we wait more. They're going to turn the camera on. Why don't you guys hold, please, while I call the court and make the proper Zoom information, and that they're going to be turning the camera on so that we don't waste the rest of our day waiting like usual. She's not 100% sure that they're using Zoom. Can you believe it? I can. So let's just hang on. Ridiculous. Sees the day says.
So I'm not 100% sure if they're using it, but I can give you the user ID.
Okay, perfect. Thank you. She said they're not 100%. She's not 100% that they're going to turn it on, but hang on a second because I have to log into the other courtroom because it follows the clerk, not the courtroom. So, that makes sense. Not really, but whatever. Quick pivot. Just a Cupcake in the Snark Tank says, I do feel like the judge was concerned about the silent mode announcement on the phone line and was saying that more in a hurry than in anger, fearing being cut off completely. Right. Yeah, mass courts. Gigi needs vow renewal song suggestions. Oh, that's great. Anybody want to give Gigi any vow renewal song suggestions? Tag her in the chat. That is her name. Gigi needs vow renewal song suggestions. She gifted 5 memberships. So help her out. Help a girl out. Okay.
Communication, and we're not moving forward on that. The only issue is that there's a change in address, and we want to make sure that the record is clear about where the defendant is living and who he is living with, because there's a house arrest.
So I believe he gave that information to probation before he even left. They gave him permission to move, so they have his address. And Judge, just so the record is clear, I know you have a jury. I'm not going to take time, but just so the record is clear, the allegation was that Mr. King did not contact anyone before he left. In fact, he was in communication with his probation officer who was out that day. That's why the probation officer here didn't know that he had called, because she was working from home because she felt bad for Mr. King because he was sick.
All right. Does probation have Mr. King's current address?
Good afternoon, Your Honor. Kia Brantley for probation. Yes, probation does have his current
Great.
address.
Okay.
Thank you, Ron.
Thank you. We'll see everybody on the 20th, or some of you on the 20th,
That
and
motion
some
is
on the
withdrawn.
24th. I'm not sure what motion you're talking about. There was a notice of violation. I didn't see a motion to revoke.
Oh, I thought that.
There
Okay,
was no
thank you.
motion filed.
Thank you.
Your Honor, thank you, Madam Clerk.
Thank you, Your Honor.
Thank you.
What had happened was it was so fast that we missed it. So I have no idea what the hell happened. What kind of bullshit is that? Well, we have from yesterday, we have Brian Walsh's court audio, and we're going to listen to that. And we're going to listen to the arguments, and we're going to listen to Judge Freniere send Walsh back to, or not back to, but send Walsh to Bridgewater State. So did we find out anything about the Proctor text messages? I'm going to have to research that while we wait, because they first sent me to the wrong Zoom courtroom. Then we got to the right one. It was already over. Okay. But here's what we do have. We're going to listen to the court audio from yesterday's Brian Walsh hearing. What had happened was nobody knows what the hell's going on in Norfolk County because they don't want you to know. And that's the reality of it. They don't want you to know. But I want you to know. So I went to the trouble of ordering the court audio from yesterday's Brian Walsh hearing. We're going to listen to it now, and we're going to hear what Judge Freniere did and why she sent Brian Walsh to Bridgewater State Hospital. So here we go. This is the hearing from yesterday. I got to make a banner so when people come in, they know. Audio from, what was yesterday's date? 10/6. Because that was a secret hearing too. That was at 12:45. And nobody knew it was on the calendar because I checked the docket like 5 times because I had a show scheduled for us to go over the pretrial conference and all the motions that were in Lemonade that were supposed to be heard yesterday, and it did not happen. But here's what did happen. Here's the audio. Let me know that you can hear it. Is Breedle. Here we go. Judge Freniere.
Good morning, Your Honor. In the matter of the Commonwealth versus Brian Walshe, indictment 2023-0091, defendant and counsel present in court. Defendants represented by attorney Larry Tipton, attorney Kelly Porges. Commonwealth is represented in these matters by ADA Ann Yaz and ADA Tracy Miner. Counsel, starting with the Commonwealth, kindly identify yourselves for the court and the record.
Good morning, Your Honor. Good afternoon. Tracy Miner for the Commonwealth.
Good afternoon, counsel.
Ann Yaz for the Commonwealth.
Welcome. Good afternoon.
Good afternoon, Your Honor. Good afternoon, everyone. Kelly Ford is on behalf of Mr. Brian Walshe.
Good afternoon.
Good afternoon, Judge. Larry Tipton for Mr. Walshe.
Welcome to all counsel. Welcome to Mr. Walshe. Please be seated. So I want to just start today with some of the motion. It refers to now attached motions, plural, and affidavits, plural, and saying that they can basically, in short order, contain HIPAA information. And then at a later paragraph in the grounds, again, it goes back to impound the affidavit, singular, again. And so I know upon my review of the pleadings initially, I saw the two affidavits of counsel, but did not see the affidavit of the doctor. But at some point I went back to either print out a different version and all of a sudden outspit a affidavit of a doctor. And it seems to me in reading the Commonwealth's opposition that at least as of the time the opposition was written, they didn't have that. It just may be in the efforts of counsel, and I understand it's time sensitive to get this to the court, that things didn't get in the right channel. So first, as an initial matter, counsel, what are you seeking to impound?
I apologize for any confusion I caused. It's only the affidavit of the psychiatrist. That's all I was asking. And that was primarily his request too, but that's it.
Okay. So, and just so that we have the record clear, let me just put his name on there, and I have it here somewhere. Dr. Tittman. All right. So now recognizing that that is in fact what a defense is seeking to impound, is the Commonwealth objecting to the impoundment of Dr. Tittman's affidavit?
No, Your Honor, the Commonwealth is not. The Commonwealth also did not see the doctor's affidavit when it received the papers, but we were provided with a copy of it today. And the Commonwealth did ask its papers be impounded based on the defendant's motion. So certainly whatever the court decides with respect to the defense papers should apply to the Commonwealth as well. We would not have independently moved to impound.
All right. In light of the fact that the Commonwealth didn't see Dr. Tittman's affidavit, and based on my recollection of that pleading, it doesn't seem to me that there's anything in the Commonwealth's opposition that's outside of or that includes anything that Dr. Tittman said, because they didn't know about it. So it seems to me it's pretty safe territory if that is.
So this is from yesterday. We went over the papers yesterday, the papers regarding the continuation of the trial. That was filed by the defendant and all of the reasons why they wanted to adjourn the trial, because Brian Walshe was attacked in jail, in the Norfolk County jail, by another inmate with a dull shank that may or may not have been a sharpened toothbrush, all the way back on September, I think 10th or 11th. He was treated and released from Norfolk County Hospital and brought back to jail. And Larry Tipton said he needs to adjourn the trial because Brian Walshe has been so traumatized by that, that he's unable to participate in his defense. We went over the papers yesterday. This hearing happened yesterday. It was secret. We couldn't tune in. So I ordered the audio. That's what we're listening to now. We went over the papers, but the doctor's affidavit was impounded. So that's what they're talking about now. And then we're going to hear what happens, because we don't know what happened. So here we go.
The Commonwealth's opposition is not impounded as well.
We went over that too. September 11th.
I just think my memory is the response. Judge, I don't think there's a legal basis for an impoundment of their response.
Okay. All right.
We read it.
So
impounded. Closing
loop on this. Dr. Tittman's affidavit will be impounded the court now conducting the required hearing under the Uniform Rules of Impoundment Procedure and better understanding what the defense's position is with regard to the requested impoundment. The court does find that there's good cause based on the factors enumerated in Rule 7 of the Uniform Rules of Impoundment to warrant the impoundment of that affidavit, and I will so order. The other documents will be put on the docket. So thank you for that clarification. So we're here in part because of the defense's concern, as was expressed in the two affidavits of counsel about the defendant's mental and to a lesser degree physical well-being, and specifically your concerns, counsel, with regard to your ability of Mr. Walshe to assist in his defense as he must. Mr. Walshe, I want to ask you a few questions. Do you understand that that is why we're here today?
Could you repeat the question?
Certainly, sir. Do you understand that your lawyers have expressed to me in affidavits? You can be seated if it's more comfortable. You're a tall man and it's more.
Okay, so apparently they got him into court yesterday at 12:45. He sounds like he's totally out of it. Is it just me? Of course there's no video for this, of course there's not. Did you expect video? Pfft, please.
Comfortable for you to be seated. All right?
Thank you, sir.
Do you understand that your attorneys have expressed to me in their pleadings and affidavits, we call them, that they have concern about your ability to participate in your defense of this case?
Yes.
All right. And do you understand that, so they've so informed me of their concerns, and based on what I read in those affidavits, as a preliminary step under the rules that govern these things, the rules require me to determine whether or not the court has any doubts as to whether you are competent to stand trial. Do you understand that?
That makes sense, yes.
All right. And then do you understand that if I find that there is a doubt as to whether or not you're competent and can assist in your defense, which just seems to be the heart of it here, that I can order an exam, and that I did this morning?
I'm sorry, could you repeat that? You said order something?
I can order an examination of you.
Yes.
Okay. And that process is something that I thought was appropriate. And so I asked Dr. Burke, or I asked that somebody, and Dr. Burke showed, to come to assess that, what we call preliminary assessment of whether or not we should do anything further. That's what happened this morning. You understand that?
I believe I'm clear on that, yes.
All right. Do you have any questions for me? I'm going to ask the doctor some questions now, but before I do you have any questions for me, sir?
Not at this time, thank you.
All right. So Dr. Burke, have you had an opportunity to meet with Mr. Walshe today?
I have. I believe I need to be sworn.
Yes.
Do you solemnly swear or affirm the testimony you give in consent?
So the doctor was in court yesterday too for this super secret hearing at 12:45, and the doctor says to the judge, "Yeah, I have some things to say, but don't I need to be sworn in?" Oh, this is great. This is great. I hear people in the chat saying crazy people don't know they're crazy. He sounds like Cosgrove. Somebody's saying, "What is going on with him? What is going on with him?" We went over all the papers yesterday. If you missed it, go back and watch. They asked to adjourn the trial because they're saying that Brian Walshe is he's got competency problems because he was attacked in jail by another prisoner, and that prisoner is being actually prosecuted in another county, even though it happened in Norfolk County because I guess conflict. So a lot of people were surmising that he tried to hurt himself, but there seems to be a perpetrator. There's a perp, but I haven't seen the papers. So we haven't seen the police report on that yet, but let's hear what his Dr. Burke has to say, because he examined Brian Walshe yesterday, and now he's going to have an opinion with regard to whether or not he's competent or needs an evaluation.
I do.
Thank you, sir. All right. So Dr. Burke, did you have an opportunity to meet with Mr. Walshe today?
Yes, we met for about 50 minutes in the presence of his attorneys.
All right. And what can you report to me? Basically, what I'd like you to know is what materials you've reviewed and what conversations and what discussions you had with Mr. Walshe before you get to any sort of preliminary opinions.
Yes, Your Honor. In addition to meeting with the defendant today, I spoke with both of his attorneys today, both before and after the interview. I spoke with the director of mental health at the Norfolk House of Correction on Friday, as well as shortly before this hearing. I also had an opportunity to review the affidavit submitted by his attorneys, as well as the affidavit submitted by his outpatient psychiatrist, Dr. Tipton. And I consulted with the area forensic director for the Department of Mental Health to determine whether he has any history of involvement with our state mental health system.
All right. And with regard to the director of mental health at the Norfolk House of Correction, who is that person, just so that I have a record of it?
Her name is Ann Collins.
And is that the full amount of information that you've had access to, those interactions with those individuals that you just indicated and the documents that you've reviewed?
Yes, I did also review the 15A order, the indictments, as well as the statement of the case.
All right. Thank you. Why don't you go ahead and tell me what you think?
Yes, Your Honor. It's my understanding from meeting with the defendant and speaking with the parties that I mentioned that he does not have a history of serious mental illness, of substance use problems, of learning disability, although he did report sort of long-term problems focusing in school. He had reported to the director of mental health at Norfolk House of Correction a prior diagnosis of narcissistic personality disorder that he seemed to be self-aware of. He's also reported his...
No shit. He's got a prior diagnosis of narcissistic personality disorder. Well, I mean, riddle me. I mean, really? Shocking.
History of depressed mood that he's struggled with in the past, and for that reason has been involved in outpatient therapy with Dr. Tipton for many years. It's my understanding from the director of mental health that he was exhibiting what she described as normative stress in the House of Correction for much of his time there. She indicated that is not uncommon and to be expected given the charges he's facing and that he had not been incarcerated previously, but that he had otherwise behaved well, not had any significant problems. It's my understanding he was stabbed on September 11th, that the attack was unprovoked, that he had not interacted with the other inmate previously, and he received medical care and was discharged the following day. It was reported to me by his attorneys that since then, he has had significant difficulty focusing. It's significantly different from their prior interactions with him where they were able to meet for 2 to 3 hours at a time, review evidence, things he might expect at trial, and that now he forgets information, he's unfocused, he seems more flustered, he seems foggier and doesn't remember things he's told them in the past. And for that reason, they've had concerns about his ability to support them in jury selection, at trial, in preparing to testify if needed. The director of mental health also informed me that following the stabbing, he has appeared jumpier, more stressed. He was on the medical unit at the facility, and when he was returned to general population, asked to go back to the unit because he was overwhelmed. He has since returned to general population. She did report that prior to the stabbing, he had also been appearing more stressed as the trial was approaching, which she also believed was a normative reaction. In my interview with the defendant today, I found him to be engaged. He did appear, I would say, foggy and unfocused at times. He described having very low energy, that he feels much less focused than he does normally, even compared to how he's been in the past, that he feels jumpier. He described having interrupted sleep, having nightmares of being stabbed again in the future, and that these problems have given him cause for concern about his ability to participate in the proceedings. He clearly indicated that he very much wanted to proceed with the trial and that he's upset that he's no longer in the same condition he was before. Concerning the questions I asked him pertaining to competency, I did find that his factual understanding of the allegations was generally intact. I did not have many concerns about his ability to understand what's happening. He seemed to know the allegations, the roles of courtroom personnel, what would be expected of him in the courtroom. I did have some concerns, however, about his ability to engage in a back and forth conversation with me. He was quite focused on his lack of energy, his lack of focus. He needed questions repeated or clarified at times, and again spoke often about the deterioration. I'm not sure if he was simply having difficulty focusing, if he's having some sort of memory impairment that's getting in the way of absorbing information. He didn't necessarily describe being preoccupied with what's happened to him, but it's not clear to me whether or not that is having a substantive impact now. It's also not clear to me that this is not just related to the stress of the trial approaching. For all those reasons, I do think further evaluation is warranted at this time. I think a more comprehensive assessment would elucidate whether he is experiencing genuine trauma symptoms right now. If he is, to the extent they're impairing him. I do think that further evaluation on an inpatient basis under Section 15B would specifically be warranted, given the magnitude of the case, the amount of data he has to review. I think an inpatient assessment would allow mental health staff to closely observe him and parse out the nature of these problems. I would also recommend the strict security of Bridgewater State Hospital, given the magnitude of the allegations against him.
All right, thank you. Does either side wish to ask Dr. Burke any additional questions? Kamal?
Yes, Your Honor. Briefly, did you look at any police reports or any investigatory reports regarding the assault on Mr. Walshe?
No, I was not provided those documents.
And did you met with the defense counsel?
I want to see him. Does anybody have him? Does anybody have the incident report from him getting attacked at the jail? I want to see it. I heard he was stabbed in the head and that he went and he was, treated and released. Doesn't mean he doesn't have a head injury or a concussion or something, but they're also saying he has PTSD after the attack.
You didn't have any conversations with anybody from the Commonwealth?
I did not speak with the Commonwealth about the case specifically, no.
And did you speak to Dr. Tipton or just his affidavit?
I was made aware of the affidavit shortly before I was going to testify, and at that point I provided the affidavit and did not seek to speak with him after reviewing it.
And that affidavit indicates that Dr. Tipton has not seen Mr. Walshe for 3 years?
The affidavit indicated that he had not seen him for 3 years up until shortly after the stabbing. I believe it was on September 24th or the 25th, and that during that meeting he found that his client was presenting substantially differently from how he had in the past and was exhibiting symptoms reminiscent or similar to PTSD, but that he could not offer that diagnosis at that time as he had not been exhibiting the symptoms for long enough.
And Dr. Tipton, his interview of the defendant in the affidavit, it was on Zoom?
Yes.
Nothing further at this time. Thank you, Your Honor.
Thank you. Does the defense wish to ask any questions of the doctor? That's a no.
The defense is like, no, we're good. We're good with his testimony. PTSD.
What's the Commonwealth's position at this point?
Your Honor, the Commonwealth's position at this point is that the Commonwealth would ask the court to find the defendant is competent to proceed to trial and continue with the trial as scheduled. Certainly, there may be some option to obtain some sort of further evaluation of what sounds like traumatic symptoms, but they do not rise to the level of a lack of competency. So the Commonwealth would ask that the court not send the defendant to Bridgewater at this point in time and continue this matter on the trial schedule.
Defense?
I think Dr. Burke has done exactly what he was asked to do, and he's recommended a 15B for all the reasons I won't repeat. I think it's imperative that his recommendation be followed and that Mr. Walshe be able to be further evaluated in a treatment setting so that we can get to the bottom of what is causing his inability to participate in his defense.
All right. You will hear this multiple times throughout the trial. I try to stay in my lane.
Oh.
My lane is not as a mental health professional. I have to rely on the mental health professionals. And based on the totality of information that's been presented to Dr. Burke, he is making the recommendation to me that a further evaluation is necessary on the issue of whether, really, it's really not so much the issue of whether he understands. He's an intelligent man. He seems to understand, based on my own observations, what's going on in this courtroom. It's whether or not he can assist in his defense.
Right.
And the court needs to have a greater satisfaction and information with regard to that. So I am going to send him for a 15B evaluation today at Bridgewater State Hospital, so that I have the benefit of whatever additional information. I expect there'll be substantial additional information based on the mental health professional's ability to examine him and see him for a more substantial period of time than Dr. Burke could in the 50 minutes that he was allowed to see the defendant.
All right, she's going to actually make a ruling that I agree with. I'm shocked. I'm shocked.
I think that it doesn't seem to me, unless counsel feels otherwise, that there's any reason to address the other grounds for the continuance at this point, those being the defense's position of late discovery of DNA, the Commonwealth's opposition that that's really relates, Judge, to the repeat testing necessitated by Gordon, and the issue that is before, I'll call it shorthand, the issue that's before Judge Krupp on discovery on Rule 14. Does either party feel like I need to address that today?
The defense doesn't.
No, Your Honor.
All right. So where does that leave us? The 20-day date is 10/27. And so what I'm going to propose to the parties is that we return to the court on that date, expecting that we will have a report in hand and that we'll be all in a better position to assess what the next steps are. And those next steps could include starting the trial that week. It could include some other thing, but I can't begin to tell what the future holds. It will be based on that information that we will, important information we'll get as a result of the 15B. But I will tell you that that could happen. If he was deemed competent, we could start the case. There'd be nothing to prevent us from starting the case at that time. And frankly, there's nothing to prevent us from starting the case any days thereafter in the event that he's found to be competent.
Your Honor, the Commonwealth has just, so I can just report to the court.
Just keep your voice up because it's hard to hear.
I apologize, sorry. Let me move a little bit, sorry. The Commonwealth is going to have huge problems if we don't start on the 20th. We're going to have huge witness problems. We've been balancing, and I keep saying we're a house of cards that is going to.
Huge. They're bringing in witnesses from Israel, Australia. Commonwealth is paying for it too. So your tax dollars are hard at work. Yeah, except discovery. Huge. Yeah, huge appeal issue if he's denied a mental health evaluation under his circumstances. You're right, does it, errata? Trial Channel says that they've got the hearing up on their channel so we can watch it after this. It's only 11 minutes. So really, we didn't miss anything. Thank you, Trial Channel.
Could collapse at any moment. We have a wedding, a baby, all kinds of things out of state, out of country. There are huge adjustments that we're going to need to make.
And none of them are more important than me assessing a defendant's mental health and ability.
I completely agree with you on that, Your Honor.
Thank you, Judge Freniere. This is Judge Diane Freniere. People are asking if it is the same judge as Kelsey's. No, there are a lot of female judges now in the state of Massachusetts, and this is Judge Freniere. It's scrolling along the bottom. She's been assigned to Brian Walshe's case since Judge Cannone was taken off of Brian Walshe's case. She had the case before Judge Freniere. She is the judge who presided over the evidentiary hearing in which we watched Yuri Bukhenik testify and Fanning testify and some other people. And it was wild. And the reason that she can't hear the motion about Proctor's communications is because the guy, the attorney that the DA's office had hired to represent them in federal court is her mentor. So that is why she deferred to Judge Krupp on that issue only. Kelsey Fitzsimmons' judge is McCarthy Naiman, but that is not the judge that we heard this morning on the bench. So I want to know if McCarthy Naiman has been taken off of Kelsey Fitzsimmons' case, because wouldn't that be great? Although the judge we heard this morning was kind of a jerk. So if you didn't watch that, go back and watch it later. But yeah, nothing is more important than this defendant getting examined. I don't care about your babies and your weddings and your witnesses coming in from Australia. Let's hear that again.
Are huge adjustments that we're going to need to make.
And none of them are more important than me assessing the defendant's mental health and ability.
I completely agree with you on that, Your Honor. My point is that we will not be ready to start on the 27th. We're going to have to make adjustments. If he comes back on the 27th and is ready to start, I'll have to give an assessment at that point of where we are. We're going to probably maybe need a week or something to assess. And I apologize for that. We have 60 witnesses. We have a very sick young woman, as you know. We're trying very hard, which is why we have the whole Gordon problem. We're trying very, very hard to keep things functioning. But
you know what I think? This is my personal opinion. They don't want Proctor's messages in the hands of Larry Tipton. That's what I think. Push it, push it, push it. Get it out quick before Judge Casper the Ghost decides to do anything about it, because they could be damning to the Commonwealth's case, in my opinion, maybe. I'm not sure who that is speaking for the Commonwealth right now. I know that Lisa Beatty usually handles it, but it doesn't sound like her voice. If anybody's in the chat that knows for real, without guessing who that attorney is, let me know.
I just want to give a forewarning that we have some witness problems.
All right, this is what I'll say to that. It is always a beast to have 60 witnesses. I get it. And there's always going to be somebody that's going to be sick, sadly. There's always going to be somebody that's going to be out of state, maybe even out of the country. They're the things that you have to juggle. I will give you some grace. And frankly, I'm not sure the defendant, if we come back here, and again, I don't have a crystal ball, but if we're coming back in a position that we have a determination by the mental health folks that he is or is not competent, but let's just say that if it comes back that he's not competent, then we're going in one direction. If it comes back that he is competent and we're ready to go forward, I'm not sure that the defense would object to another week so that they could have meaningful conversations with the defendant when he's not in Bridgewater, because that presents other challenges. So I'll give you some grace with regard to that. But the court does have an interest. I think all of us have an interest in seeing the case move forward for all parties concerned, both the Commonwealth and Mr. Walsh. So we'll take it one step at a time. I'm sending him for the 15B because I don't have those kind of superpowers to know what the mental health people are going to say. And I need the benefit of that before we can make next decisions. I'm just saying to you that it's my expectation that if we don't want too much time to pass, what I've always thought was very strange, not in this case, but in other criminal cases, you have a competency examination, and then 6 months to 12 months later, the court is hearing the case. And it's, to me, it's that competency evaluation that was done a year ago is sort of meaningless because it doesn't reflect where the defendant is today. So I'm interested, once we get the report, whichever direction it goes in, that we move meaningfully towards the next sort of best practices step. So I don't want there to be 6 months between if he's found to be competent and the time that he goes, we'll just circle back to the same thing. So be prepared to be agile with regard to your respective roles once we have the information in hand.
Thank you very much, Your Honor.
Does the defense wish to be heard on any, and I know, again, you don't have the crystal ball either, but on anything that the Commonwealth said?
No.
All right, thank you, counsel.
May I ask a housekeeping question, Your Honor?
Yes.
Because the defendant will be presumably at Bridgewater, will we be going forward tomorrow on the motions, or I assume we'll be continuing them to some future date?
It doesn't seem to me to make, first of all, I want the defendant present while those motions are being discussed.
Yes, Your Honor.
And I don't know that it makes any sense, and particularly where We certainly could have accommodated it to go forward tomorrow, but I don't think the defense, if you filed them, I haven't seen them yet, got a chance to oppose the Commonwealth's motions in limine. And so I haven't seen those yet. And I did see the Commonwealth opposed. They came in, but I haven't read any of them. But I'm not inclined to go forward tomorrow. He's going to be at Bridgewater starting the process of this evaluation. But I'll hear from the other side if you think differently. Defense? No.
At this time, I don't think it makes sense to go forward tomorrow.
I don't either. All right. So we will next see each other on the 27th. And I think I promised you a long time ago, but I didn't deliver on the promise. At least I don't remember if I delivered on the promise. A questionnaire that I was thinking of. Did I ever get that to the parties? All right. I didn't forget about it. I've been working on it again. So I'll get that out to you just so that we're keeping things moving. I've already done it. So there's no reason not to give that to you anyway. And then you can ruminate on that and see if there's anything else that you want added in there. If there's anything else that I can think of that you would benefit from, I'll share that with you as well. But I know I had promised you that questionnaire and never got it to you. So I'll get it to you now. Anything else that the court can do to assist the parties getting ready?
With that 9 a.m. on the 27th?
Yes. Defense? All set?
Thank you, Your Honor.
Thank you very much.
Mr. Tipton, just one matter. You have you were scheduled to go before Judge Krupp tomorrow at 9. Do you want to move that to 2 o'clock with the other defendants and waive your client's appearance?
He won't be here. No, I keep it on at 9.
Keep it on at 9? All right.
I think, I haven't been following that, but had he waived his presence at that hearing anyway?
It's been
waived.
He hasn't been going to those. I haven't been participating. I just have been waiting patiently. All right. Thank you.
Matters continue to October 27th at 9 a.m. for further hearing. Defendants removed.
Thank you, Doctor.
Thank you, Your Honor.
Okay, so that is the recording that I ordered from FTR. It cost me $10, but it's worth it. It's worth it for you guys. All right, Brian Walshe is going off to Bridgewater State for 20 days, and we will come back for a competency hearing for Brian Walshe on October 27th. Now we're going to go to the recording or the video, courtesy of Trial Channel, from the hearing that we missed this morning because it was over so quickly because they sent us the wrong Zoom room. And then when we got into the Zoom room, but look at this, Trial Channel has the actual video. So it's even better. So aren't you glad you hung around? Shout out to Trial Channel. Give them a sub and a like if you like to watch trial testimony broken down into easy bite-sized pieces with where they cut out the breaks and the lunches and everything. That's the channel for you. And they're growing really quickly. I don't know how many subs you guys already have, but like this is one of the fastest growing channels I've ever seen. Let me see. What are you up to? Almost 40,000 subs. I mean, you guys are really like 10 minutes old, right? I don't know, but it seems like it. All right, here's the hearing from this morning. So let's go back to that. Change the banner again. All right, this is the video. Rosemary Scapicchio is my spirit animal. Maybe yours too. Here you go.
Good afternoon, Your Honor. Kelly Ford is on behalf of Mr. Walshe.
Okay. Afternoon, Larry Tipton on behalf of Mr. Walshe. Thank you. Attorney Krosky Jr. on behalf of Mr. Della Santos.
And good afternoon, Your Honor. Rosemary speaking on behalf of Mr. King and Mr. Johnson, who is here, and I expect in the courtrum momentarily, Judge.
And I see Mr. Cataldo on Zoom.
Yes, good afternoon, Your Honor. Joseph Cataldo on behalf of Bianca Ciancio.
Okay, let's just give it a minute until the two defendants in custody get into the courtroom.
Thank you, Your Honor. No, yes.
Oh, I love Larry Tipton. Larry Tipton defended Penny McGee, and Penny McGee was acquitted by Judge Cannone. He's the best public defender in Massachusetts. Fight me on it.
Ms. Portis, Mr. Tipton, do you folks have a trial date?
We have an October 27.
27.
It's
Contingent now, I understand.
Contingent.
Okay.
It is the Kent Reed courtroom. You are correct. Courtroom 25. Very good eye. Good eye, Deborah. It's Joe Krasky. You might recognize him from Court TV.
Now, President, we just had the lawyers introduce themselves, but beyond that, we didn't do any business before you folks got into the courtroom. So, Ms. Beatty, what's the current status?
I'm able to report that I believe that we have an agreement with the U.S. Attorney's Office, and that after our review, there are materials that we would like to produce.
I'm gonna just I'll boost their audio so it matches mine. Hang on.
Some discovery that requires Judge Casper to act, and it's my understanding with these office.
So beyond that, we didn't do any business before you folks got into the courtroom. So, Ms. Beatty, what's the current status?
I'm able to report that I believe that we have an agreement with the U.S. Attorney's Office, and that after our review, there are materials that we would like to produce in discovery that requires Judge Casper to act. And it's my understanding that they have or will be moving for that disclosure, permission for that disclosure in front of Judge Casper. Other than that, I can't give you an update on the timing, but certainly this office and the U.S. Attorney's Office are anxious to resolve this sooner rather than later. And so I'd ask for another week or two.
Okay.
Your Honor, I feel like this is just the same argument that we have every single
It's not
time.
the same argument. They're making progress. We're making progress. In a couple of weeks, hopefully, this will be fully resolved.
I understand, Judge.
With an approval, with an order from Judge Casper authorizing.
Couple of weeks? Really?
Authorize the DA's office to turn over what they believe to be exculpatory evidence.
Understood, Judge. My concern is that it's the 7th of October. A couple of weeks is going to bring us right up against that 20th destruction date. I'm not due to come back here until the 23rd on a bail argument for Mr. Johnson. So I don't know what that does to the destruction order. When I had a conversation with the Commonwealth this morning, I asked them whether or not they were going to seek additional time because I'm very concerned about the destruction order. And they indicated they didn't think they needed it. But if they're asking for 2 weeks, Judge, it's right up against the 20th. And I don't know what we do about that.
What do you think we do about that? Pretty basic.
I've consistently reported to the court and counsel that we will not destroy or return prior to coming back before this court. So we can come back to court on the 17th, but I think it makes more sense to come back on the 20th.
Okay.
But either is fine with me.
The 20th is the day that the messages are going to self-destruct. So of course you'd love to come back on the 20th to tell the court that Casper the Ghost has once again ghosted you. Now that you have represented to the worldwide audience and the court that you believe that there are communications that are relevant to the rest of these defendants' cases, because Proctor probably maybe was looking for nudes in somebody else's phone. And that's maybe just the least of it. Right? Because if he said such horrific things about the defendant, Karen Reed, what kind of horrible things do you think he was saying about every other defendant out there that he may or may not have been the lead investigator on? So yeah, let's just bump it to the date that it's supposed to self-destruct, right? And they will have destroyed them before they get back, says Wags. And Magnolia Gypsy said, she said they would come back with exactly this. Rosemary did. She called it. Yep. Let's listen to that again. Lisa Beatty with the abada, abada, abada. Here you go.
I've consistently reported to the court and counsel that we will not destroy or return prior to coming back before this court. So we can come back to court on the 17th, but I think it makes more sense to come back on the 20th. But either is fine with me.
Judge, I can't be here on the 20th. I'm starting a trial. Well, I'm on trial in Suffolk right now in front of Judge Halal. So I won't be available on the 20th. We think this case will probably go to the jury on the 22nd or the morning of the 23rd. And we're already back here on the 23rd. But I don't want to hold anyone else up. Everyone else somebody can stand in for me, I'm assuming. I'm just worried about the 20th.
I'm here on the 20th, Judge, if I might, so I could certainly stand in and represent the extent that I can our interests regarding this issue. I also am calendared for the 23rd, so I can be here on both dates, but the 20th, I think, coincides with the date of the order, so I think it makes sense to bump my date from the 23rd to the 20th so that we have someone here on that day.
That makes sense. Put it up for the 20th?
It would have to be at 2 because the sentence appeals are in the morning.
Okay, 2 would be fine.
I'm here too on that day.
Okay, and that's a week before Walsh is supposed to begin, at least contingently.
And Judge, I'm here on the 23rd on the bail issue for Mr. Johnson.
Okay. We'll see you on the 20th. Well, you are in this session on the 23rd?
I think it's going to go before you. I don't know if it goes before you or anybody else. It doesn't.
I just have to leave here probably a little bit before 3 on the 23rd to get to a class I have to teach that afternoon. And I believe we potentially scheduled very few things on the afternoon of the 23rd. Let's just make sure that the 23rd is okay.
And I'll keep the court updated if for any reason my trial runs over than what I thought it was going to be.
Hang on one sec. We'll just check the 23rd. Okay, so we'll put all of the cases on for the 20th at 2. And Mr. Krosky will work at. Mr. Cataldo, does that work for you?
It does, Your Honor. I'm asking for the 20th at 2 and ask that my client's appearance be waived. And it's my understanding that the 23rd for Chianchio will be off. We'll do that on the 20th?
Neither of those cases are scheduled for the 23rd.
It was a bail argument for Mr. Johnson. I think that might have been.
23rd, we have 4 matters and they're all quite manageable before 3 o'clock. We can put a bail argument on for the 23rd.
I thought was that the date we picked? Yeah, I thought that was the date we picked last time we were in front of you, Judge.
Okay, may just not have made it on the master.
Just a reminder that Michael Proctor's next hearing dates for his appeal of his termination are scheduled for October 21, 22, and 23. So, you know, chop, chop.
And I don't want to interrupt, well, I guess I'm interrupting, but I just want to make sure because I want to slot Mr. De Los Santos in too. I don't know if it's already made mass courts, but I know we drafted motions for discovery and a bail motion. If they haven't been served yet, they will be served probably by the end of the week. I'm happy to do it on the 20th. Or I'm also happy to come back the 23rd, be here both days that week.
I am not going to hear it on the 20th. I am trying to keep the 20th clear from the trial, full day of trial on that day. So if it takes 10 minutes to address these issues with regard to the Proctor discovery, that's fine. But if it's going to be a full-blown bail hearing, we're going to have to pick another day. And the 23rd is going to get clustered, you know, and cumbersome. We're going to hear a bail argument and the other 4 matters.
Oh, it's a cluster, all right. You can say that again, Judge Krupp. It's a cluster.
So we'll need to pick another date for hearings on the other cases.
So I think
Who's
Johnson.
the prosecutor with respect to De Los Santos, Mr. De Los Santos?
That's me, Your Honor.
Okay.
And they're co-defendants with Johnson and De Los Santos.
Okay.
So I'll be here on the 20th to make sure that there's representation related to the Proctor discovery. And then you want me to pick a different date for the bail and discovery motions.
Right.
Okay.
And you don't even know if they've been filed. So.
If they haven't been, they will be shortly.
I've not received anything.
Okay.
And I'm gonna be on trial until.
Maybe the 20th, right. So how about the 24th?
I can be here 2 o'clock on the 24th.
Curtis, could you put Johnson on for the afternoon of the 24th?
I just checked, Judge. Only because I'm starting another trial in Suffolk on November 3rd, and I don't know if that's the final pre-trial.
These are other cases that they're talking about now. And she, Rosemary, is a very busy woman.
So. October 24th?
Yep.
I can actually, Judge, because a motion for evidentiary hearing, a motion for new trial in front of Judge Campo just moved yesterday.
Okay.
So
you
yes.
can do the 24th. All right.
Yes.
So we'll put both Mr. Johnson and Mr. De Los Santos on for a hearing on the 24th at 2. Ms. Blair will be done with her trial by then.
Hopefully I'll be done with mine. Hopefully I'll be done with mine and in
Done with
between.
yours, and I'll see Mr. Krowski and anybody else who can attend on the 20th in the afternoon with regard to Dr. Discovery.
And may Mr. Johnson be brought in on the 20th just so that he knows what's going on, even though I'm not going to be here.
I think the answer is yes, it can be done.
Thank you.
But I wonder if it makes sense just to have him brought in on the 24th, since he'll be fully up to speed by the 24th.
That's fine, Your Honor.
All right. His presence will be waived on the 20th. We will not bring him in, and we'll bring him in on the 24th. Mr. De Los Santos, too. It may probably make sense to do the same with Mr. De Los Santos.
We would waive his appearance on the 20th. I'll be here. He'll come in on the 24th.
Fine. Okay. Very good. Anything else?
Your Honor,
Just one
Your Honor,
matter.
Go ahead, Attorney Beatty. Go ahead.
I don't want to interrupt Mr. Cataldo.
Mr. Cataldo,
I just want to be clear about Chianchio's next date.
her presence is waived on the 20th.
Okay, thank you.
We have one lingering issue with regard to Mr. King.
Yes, Your Honor.
This is a GPS monitoring with regard to the curfew. He left his home to go to the hospital.
Yes,
Is that it?
With probation's permission, Judge.
and his address.
So Judge,
Yeah, so Myles King violated his, remember they had to let him out of jail because they were holding him for like 3 years. And Lally never turned over those search warrants that he had in his possession for 6 years. And we were in the middle of that evidentiary hearing while Lally was on the stand and he was being questioned about why. And all of a sudden they cut that hearing off. Proctor was in the hallway ready to be examined next. This was only on the Myles King case. And all of a sudden they just halted that hearing for no apparent reason. And I have no idea when that's going to happen again. But Myles King was then let out on bail. And then he violated his bail conditions by leaving his house without permission. But it sounds like they're not taking him back into custody. It sounds like they never took him into custody. Let's just take that back a notch.
We have one lingering issue with regard to Mr. King.
yes, Your Honor.
This is a GPS monitoring with regard to the curfew. He left his home to go to the hospital.
Yes,
Is that it?
With probation's permission, Judge.
and his address.
He
So
moved.
Judge, they issued a warrant for Mr. King because I can say, Judge, that his probation officer was not working the day that she was actually off that day, but she was communicating.
Hang on 1 second, okay? There was a violation of GPS curfew, leaving the house without prior, without having gotten it to us. Is there another issue?
No, we understand there was a miscommunication and we're not moving forward on that. The only issue is that there's a change in address and we want to make sure that the record is clear about where the defendant is living and who he is living with, because there's a house
So I
arrest.
believe he gave that information to probation before he even left. They gave him permission to move. So they have his address. And Judge, just so the record is clear, I know you have a jury, I'm not going to take time, but just so the record is clear, the allegation was that Mr. King did not contact anyone before he left. In fact, he was in communication with his probation officer who was out that day. That's why the probation officers here didn't know that he had called, because she was working from home because she felt bad for Mr. King because he was sick.
All right. Does probation have Mr. King's current address?
Good afternoon, Your Honor. Kia Brantley for probation. Yes, probation does have his current
Great.
address.
Okay,
Thank you, Your Honor.
thank you. We'll see everybody on the 20th, or some of you on the 20th.
That
and
motion's
some on the
withdrawn.
24th. I'm not sure
Revocation.
what motion you're talking about. There was a notice of violation. I didn't see a motion to revoke.
Oh, I thought
There was no motion filed.
Thank you.
Your Honor, thank you, Madam Clerk.
Thank you, Your Honor.
Thank you.
G, office the crop, gay, crop you. Okay, let's come back the day that the messages are set to self-destruct. And the reason people are asking in the chat, why are they self-destructing, is because the federal protective order keeps getting extended, and it has been extended yet again. And it is they're set to destroy, they're supposed to destroy all these Proctor communications on October 20th. But we're just going to push it out to October 20th at 2 p.m. anyway. And then what happens at close of business at COB on the 20th? Are they going to just self-destruct then? Are they going to have an answer from Judge Casper the Ghost or not? How about you pick up the phone and you call the judge and you say, Judge, listen, Judge, professional courtesy, one judge to another. hey, I really got to move these cases. I got to move these cases. You know, they're all up my butt over here in Norfolk County. You heard about the Karen Reed persecution, right? Yeah, 2 trials. I know, it's crazy. Well, listen, I'm under a lot of trouble here. I got a lot of heat on me. People are looking. The world is watching, Judge Casper the Ghost. And listen, if I don't do something quick, everyone's going to be making fun of me all over YouTube. They're going to be making fun of me. They're going to say that I just keep kicking the can down the road because, you know, I kind of am. But, you know, there comes a point where we got to do something because Proctor's hearings are coming up. He's trying to get his job back. That's October 21, 22, 23. I don't know. Is there a chance that whatever's going to be released to these defendants that is relevant in their cases, according to, you just heard it from the Commonwealth's mouth, is there a chance that what's going to be released in these other text messages might throw a thorn into, you know, Michael Proctor trying to get his job back? Is it only obvious to me? Judge Casper is the federal judge who's got to rule on this. It's egregious. I know. And the thing is that, you know, I said last time, I'm like, listen, these take a while, you know, it gets all right, now I'm mad. Now I'm mad. I'm done with this. I'm done. This is insane. Okay, good. Let's come back October 20th. So thank you, Trial Channel, for doing the Lord's work and putting that up on your channel so quickly that it didn't even matter that we missed the Zoom this morning because your feed was way better because you got the feed that we all wanted to see. You know, after we're done answering questions, we're going to look at Karen Reed's opposition papers for the hearing that's supposed to be tomorrow at 2 p.m. to get her phones. I think that's in front of Krupp too, right? The world is watching, and we don't like what we're seeing here. And you're not going to fool us, and we're outraged. Helena said the latest Canton cover-up is mind-blowing if we have a minute. I don't know if I'm going to have a minute, Helena. Thanks for tuning in, though, from Sweden. I'm going to see Yes tonight, and I need a nap. And I got to read these papers. So everyone go on over to Turtle Boy, Turtle Boy's website and read it because I don't think I'm going to have time. New Hampshire woman says, come on, kids, show Melanie a little love and smash that button. Come on, kids. We did that already. Thank you. Thank you, Hates Me, for your 10. I think we looked at this earlier, too. Thank you for being you. I appreciate your snark, wit, and commentary. I hate when I miss the live like I did this morning, but I will replay. That's okay. I forgive you. Thank you for your 10. Gigi needs vow renewal song suggest. I can't. It's hard for me to like suggest songs for you if I don't know your musical taste. Thank you for your 20. Change my name so maybe people can help me with our songs. Melanie has good taste in music. We have made it farther than 10 years, so very special. Appreciate any suggestions. I have to think about it. Did anybody put any suggestions in the chat yet? I mean, I'm sure there's a million Dave Matthews songs that would be good. I can't really think of any Grateful Dead songs, but everybody Wang Chung tonight. Come on, Tom Gully. Come on, you guys. Can you think of one? Crash Into Me? How about You and Me? How about yeah, we need more. Timeless by Taylor Swift. We need more information. We need to know what you like, you know? I mean, What a Wonderful World. Louis Armstrong is always a good song. You don't need to just only have one. You know, In My Life by the Beatles is always a good wedding song. She really needs suggestions, you guys. So if you could help her out, that'd be great because my brain is mush. Weekend at Bevy says, will Walsh have doctor-patient privilege confidentiality like a lawyer and client do? No, because it's a court-ordered evaluation. And so the court is privy to, you know, their conversations and stuff like that. I don't know if we will get a copy of the report, but no, there's no confidentiality because his job is to report back to the court. And so everything he says will be monitored. Weekend at Bevy's, I think, while he's undergoing his evaluation in the hospital. It is a prison hospital, right? So I don't think there's any confidentiality. But if somebody knows, because they work at Bridgewater State, let me know if all of the evaluations are monitored. I would imagine that they are, but I honestly don't know for sure. So thank you so much for your 5. Cosgrove's Getaway Driver gifted 5 memberships. And that is an amazing. Oh, that's a great song. I Will by the Beatles. Weird Debbie suggests. That's a good one. If I fell in love with you, that's a good one, Michael. Except it's their vow renewal. So like, think of a song like, looks like we made it. That's a good one. I don't know. I think it's song lyrics. Thank you, Cosgrove's getaway car. KLM, are you going to be reading the new document in the Karen Reed case today? Well, I have it pulled up so we can. It's 13 pages. We'll read that. And then I'm going to go take a nap. So we'll read that. And then we're going to come back for the hearing tomorrow. Okay. Thank you for 5. Marie, thank you. Zach says, narcissists love to have their comments read out. I know. I saw you baiting me in the chat. I told you I'm not getting rage baited today. In fact, I did highlight something that you said earlier to me. And now you're paying $2. If I see any narcissists, I'll let you know. So I don't know if you're a dick or if you're just trying to be funny. And here it is. If I could get Melanie to look aggravated and say, what is wrong with you? My job would be complete. I don't know. You were in here this morning saying I've already been here for 10 minutes and I haven't been timed out. So it was like, a reality check. I don't know if you're kidding or not, but I'm not in the mood really today. What's wrong with you, Zach? What's wrong with you? Does it make you feel better? What about info you found on Ana and her boss in Washington, D.C.? Oh, we talked about that, girl, like 3 shows ago. Thank you, though. Thanks, Ms. Holmes. You got to go back and look for it. It's a timestamp. It's hard. I can't be repeating myself every single stream because I'll make all of you crazy and me. Gigi, and again, says, can you give me a song? Had to leave my ice cream truck and engraved silver bracelets behind for now. So much more important to me. My love after giving up on love. I have to think about it. I can't be put on the spot like that. When is your vow renewal? Like tomorrow? Is it like tomorrow? Adele has many songs you could pick from, says says Jen and Toxic. Emily C says, Melanie, ignore Zach. I'm working on it with him in kindergarten. Cosgrove's Reverse Mortgage says, Together Forever by Rick Astley, Simply the Best by Tina Turner. Here you go. You were always on my mind, Willie Nelson. Funny how time slips away. That's a good one too. Another Willie Nelson tune, right? Oh, Gigi's not here. She split. All right. Zach trolls everybody, especially Nurse Kim. Oh, is that true? Because if that's true, then I gotta get rid of him. Zach is everywhere. You're Still the One by Shania Twain. All right. Thanks, Lynette, for becoming a new member. All right, let's look at the papers on Ms. Reed's memorandum in opposition to the Commonwealth's motion for examination of digital material. This is Cosgrove trying to make a motion to now appoint a taint team to look at Karen Reed's phones. And they have opposed this motion. It is supposed to be heard tomorrow at 2 p.m. And if we can, where's the plug for Paris Ray? Well, you know what? Paris Ray and the Crush will play us out today, Davy Cakes. Don't you worry. I do it at the end. They play us out. It's the only music I can play without being stricken. Okay. All right. Let's look at the papers. Okay. Here we go. Love Will Find a Way by Yes. That's a good one, Desiderata. Thank you for Gigi. What could be more outrageous? Says Kevin from South Boston. He's here. He's a decorated dude. And then just to watch us says, so what happens when Walsh gets pushed to trial? A jury gets sworn and then the Proctor text hit. Is that an automatic mistrial? And now they're going to have him before they can start that trial, I would say. Lynette became a member. Welcome. And thank you, Mrs. Bukai. Good night. It's later over there across the pond. Have a great evening. You as well. Thanks, Marie, for becoming a member. Okay, here we go. Papers are here. It's only 13 pages. I'm going to read through it, and then we will talk about it afterwards. Okay, here we go. This is Ms. Reed's memorandum in opposition to Commonwealth's motion for examination of digital materials seized from Karen Reed pursuant to search warrant issued on January 22nd of 2024. Now comes Karen Reed, a third party to this matter, because the caption is Commonwealth of Massachusetts versus Aiden Carney, which is weird. And again, it is filed under a search warrant number, so I don't even know. I haven't even checked mass courts yet to see if that actual case number is in the docket. So I don't know. But in this proceeding, Karen Reed is a third party to this matter and respectfully requests that the court deny the Commonwealth's motion for examination of digital material seized from Karen Reed pursuant to search warrant issued on January 22nd, 2024. The Commonwealth has no probable cause whatsoever to believe there's any new evidence of criminal activity contained within Ms. Reed's cell phones because any information that the Commonwealth might hope to glean from the requested records is duplicative of the information already contained in Mr. Carney's cell phone records, which have been in the Commonwealth's possession since the start of this case. Oops, take the banner down, hold on. Gotta take down the banner. Don't want to confuse anybody. The Commonwealth has no probable cause whatsoever to believe there is any new information of criminal activity contained within Ms. Reed's cell phones because any information, I already read that sentence. The Commonwealth has failed to allege particularized facts that any information contained in Ms. Reed's cellular records beyond information that is already in the Commonwealth's possession is relevant in any way. This court should return Ms. Reed's personal property immediately. Factual background. Ms. Reed's phone was searched by the MSP pursuant to a search warrant issued on February 2nd of 2022. 4 months later, on June 9th, 2022, Ms. Reed was arrested a second time for the same incident. We've seen it. We've seen the body cam. We were there. On January 24, 2024, Lieutenant John Fanning seized 2 more of Ms. Reed's cell phones pursuant to a seizure warrant issued on the basis of, quote, witness intimidation allegedly perpetrated by Ms. Reed. On March 27th, 2024, unbeknownst to Ms. Reed, the Commonwealth convened a grand jury to determine whether a true bill should issue, requiring Ms. Reed to stand trial for numerous counts of conspiring with Mr. Carney to engage in witness intimidation and or harassment against Brian Albert, Colin Albert, Chris Albert, Jennifer McCabe, Matthew McCabe, and former Trooper Michael Proctor. On the very same day, March 27th, 2024, the grand jury concluded that there was insufficient evidence to find probable cause that Ms. Reed committed the acts of intimidating or harassing the witnesses, officially rejecting the Commonwealth's allegations. On July 1, 2024, a mistrial was declared, praise be, after the jury deadlocked. Oh no, not praise be. Praise be when she was acquitted. Ms. Reed did not learn about the grand jury's rejection of her alleged involvement in witness intimidation until a notice of discovery produced by the Commonwealth on October 10th of 2024, approximately 6 months later. Oh, so they didn't even tell Karen Reed's attorneys that before trial number 1, there was a grand jury convened for witness intimidation, and they failed to indict the ham sandwich of Karen Reed and Aidan Carney. They didn't tell her attorneys until 6 months after the mistrial. Anybody think that's a problem? Anyone? Anybody think that the grand jury transcript might have been relevant in trial number 1? It's just another example of them hiding the ball, shoving things in drawers, not having evidentiary hearings, and there's never ramifications for their behavior, ever. Ever. On April 22nd, 2025, 1 year after the start of her first murder trial, Ms. Reed was retried for second-degree murder, manslaughter, and leaving the scene. On June 18th of 2025, the 3.5-year saga came to a just end when the jury acquitted Ms. Reed of all charges related to John O'Keefe's death. That's where I say praise be. After her acquittal, the Commonwealth remained in possession of Ms. Reed's personal property. On July 28th, 2025, Ms. Reed filed 2 motions for the return of her property, one for her Lexus SUV and cell phone seized on January 29th of 2022, and a second for the 2 cell phones seized on January 24th, 2024. Ms. Reed's motion to return her vehicle and cell phone that was seized on January 29, 2022 was granted without objection on August 11th, 2025. Rather than complying with Ms. Reed's motion to return her 2 cell phones that were seized on January 24th, 2024, however, the Commonwealth submitted the instant motion for examination of Ms. Reed's latter 2 cell phones, right? Cosgrove filed this. I have no idea when he was appointed to prosecute Karen Reed, but maybe we'll find out. And here's the argument. Roman 1, legal, landscape, and evidentiary standard. In Massachusetts, like many other states, prosecutors may, in certain circumstances, present identical evidence to a second grand jury after failing to obtain an indictment from a first grand jury. See Commonwealth v. McCravey. However, this power is not absolute. The purpose of indictment by a grand jury is to shield the innocent against hasty, malicious, and oppressive public prosecutions. Repeated submissions of identical evidence to successive grand juries, especially in light of harassing, malicious, and biased prosecutions, poses a limitation on the prosecution's ability to resubmit evidence to a new grand jury. For example, when a governmental body has no legitimate or reasonable purpose for pursuing an indictment by grand jury after repeated attempts, the court may inquire into the prosecution's stated purpose and prevent resubmission. Yeah, we'd like to know what their purpose is. In Commonwealth v. McCravey, the Massachusetts SJC stated that it would bear consideration whether submission of the same evidence to multiple grand juries would be inconsistent with the purpose of grand juries to shield the innocent against hasty, malicious, and oppressive public prosecutions. While it is the general rule that a court should not inquire into the adequacy or competency of the evidence upon which an indictment is based, when it appears that the integrity of the grand jury process has been impaired, a defendant may attack the validity of the indictment by way of a motion to dismiss. Although no indictment has been secured in this case, the process of seeking same bears on the analysis similarly. Improperly seeking evidence under the guise of later seeking an indictment impairs the process from the outset, which the courts are loath to sanction. Right. The pertinent witness intimidation statute reads as follows. Whoever willfully, either directly or indirectly, 1, threatens, attempts, or causes physical or emotional or economic injury or property damage to, conveys a gift, offer, or promise of anything of value to, or misleads, intimidates, or harasses another person who is a witness or potential witness, a person who is or was aware of information, records, documents, or objects that relate to a violation of a criminal law or a violation of conditions of probation, parole, bail, or other court order. Judge, juror, grand juror, attorney, victim, witness, advocate, police officer, correction officer, federal agent, investigator, clerk, court officer, court reporter, court interpreter, probation officer, or parole officer. D, person who is or was attending, or a person who has made known an intention to attend a proceeding described in this section. So anybody who's going to attend any proceeding described in this section, this is so overly broad. In my opinion, it's unconstitutional, but they didn't ask me. Or a family member of a person described in this section with the intent to, or with reckless disregard for the fact that it may, if your eyes are glazing over, so are mine. 1, impede, obstruct, delay, prevent, or otherwise interfere with a criminal investigation at any stage, a grand jury proceeding, a dangerousness hearing, a motion hearing, a trial or other criminal proceeding of any type, or a parole hearing, parole violation proceeding, or probation violation proceeding, or an administrative hearing, or a probate or family court proceeding, juvenile proceeding, housing proceeding, land proceeding, clerk's hearing, court-ordered mediation, or any other civil proceeding of any type. Or punish, harm, or otherwise retaliate against any such person described in this section for such person or such person's family members' participation in any of the proceedings described in this section shall be punished. Okay. I can think of about 10 other examples of this by people who were inside the house of 34 Fairview, but they haven't been prosecuted under this witness intimidation statute. And also, maybe Chris Albert, threatening John Camo, the other day as he brought out at the, could he potentially be a witness in something at some point ever? Maybe. This is insane. Yeah, and it says funny how this is coming out when Karen included the Commonwealth into her lawsuit. However, I do believe this motion was filed before that happened. Somebody can check the dates for me if you want, but I thought that too. But then I thought that hearing happened after this motion was filed, I'm pretty sure. Article 14 of the Massachusetts Constitution requires that all searches and seizures be reasonable. Searches and seizures conducted outside the scope of a valid warrant are presumed to be unreasonable and therefore unconstitutional. Well, tell that to Judge Freniere, because a lot of you in the chat must not have been here when we went over the denial of the motion to suppress on Brian Walshe, because you thought she was a really great judge during the hearing, where she just sent Brian Walshe for a grippy sock vacation and evaluation, but I think was wrong on the search outside the valid warrant and consent agreement. So there's that. To be reasonable in the constitutional sense, a search conducted pursuant to a warrant must be supported by probable cause. To comport with constitutional protections, an affidavit in support of a search warrant must demonstrate probable cause to believe, 1, that a particularly described offense has been, is being, or is about to be committed, and 2, that the search will produce evidence of such offense or will aid in the apprehension of a person who the applicant has probable cause to believe has committed, is committing, or is about to commit such offense. In addition, a cell phone search must be timely. The state must act within a reasonable period after seizure, else the seized material must be excluded. And that is citing a case that was just decided within the last month. Commonwealth v. Diaz, August 29th, 2025. So the question here is going to be, is it timely to wait a year and a half since seizure to now all of a sudden ask to search it? Because if you didn't have any cell phone extractions when you tried to indict the ham sandwich, what evidence did you have? And why didn't you ask for it back then? There's so many questions here, but we know the shenanigans that happen. Roman 2, the Commonwealth has no legitimate purpose for its motion and is simply attempting to continue its persecution of Karen Reed. Well said. The Commonwealth lacks the necessary probable cause to support their requested search warrant because the requested search will not produce evidence of the alleged offense, nor will it aid in the apprehension of an alleged perpetrator. The basis of the Commonwealth's inquiry into Ms. Reed for the offense of witness intimidation is a groundless allegation of indirect witness intimidation. This is evidenced by Trooper Tully's supporting affidavit, which only describes conclusory allegations of witness intimidation as occurring through Ms. Reed's communications with Mr. Carney. It is murky whether he believes those communications were direct or indirect, and he has no stated foundation that any communications actually are in furtherance of witness intimidation. Rather, Tully spends nearly the entire affidavit describing Carney's alleged conduct, not Ms. Reed's. The communications presented by Trooper Tully between Mr. Carney and Ms. Reed actually show the opposite of witness intimidation. She is clear that information should not be used or disclosed or disseminated. There's absolutely no evidence of Ms. Reed ever urging or even suggesting to Mr. Carney that any witness be contacted, approached, or even discussed in Mr. Carney's reporting. Further, the Commonwealth lacks probable cause to search Ms. Reed's cell phones in accordance with either of the standards in the second prong of the Estabrook test because they are already in possession of all information pertinent to the prospective allegations. Paragraphs 7 through 41 of Tully's affidavit have nothing whatsoever to do with Ms. Reed and only concern Mr. Carney. Paragraph 44 of Trooper Tully's affidavit perfectly encapsulates the reason why the search warrant is unnecessary and why the Commonwealth lacks probable cause to search Ms. Reed's phones, period. Paragraph 44 reads, quote, Natalie described the arrangement as follows. Karen would send Natalie a message on Signal intended for Carney. Natalie would copy and paste the message, photo, video, document into a text message to Carney. On several occasions, Natalie would take a screenshot of the signal messages from Karen and send Carney the screenshot. Natalie stated she would send information to 2 phone numbers used by Carney. Because the Commonwealth's groundless allegation seeks to suggest that Ms. Reed communicated some unknown things to Mr. Carney, and he thereafter engaged in witness intimidation, the only relevant communications would be those actually received by Mr. Carney. That's a good argument. For example, if a hypothetical communication was written by Ms. Reed on her phone, but not passed along to Mr. Carney, that cannot possibly be an example of witness intimidation, as the Commonwealth has not and does not allege that Ms. Reed actually carried out any intimidation herself. Therefore, as all relevant communications would be those received by Mr. Carney, and the Commonwealth is already in possession of all communications received by Mr. Carney, because the Commonwealth has searched the entirety of his phone, it is impossible that a search of Ms. Reed's phone would produce any evidence, communication, that is not already in the Commonwealth's possession. Footnote 1. The same reasoning applies to the following paragraphs of Trooper Tully's affidavit, as the Commonwealth is already in possession of Mr. Carney's cell phone messages, and there's like a million other paragraphs mentioned there in that footnote. The Commonwealth has the other side of the handshake, if such exists. Therefore, the Commonwealth lacks probable cause to search Ms. Reed's phones, and the Commonwealth's motion should be denied. The final paragraph of Trooper Tully's affidavit expose what this motion and the Commonwealth's overall plan truly is: an overbroad and persecutory fishing expedition intended to punish and harass Ms. Reed. In paragraphs 96, 97, and 100, Trooper Tully states as a reason for searching Ms. Reed's cell phones that the MSP needs to examine Ms. Reed's location data and app usage, which is literally everything on the phone, to determine whether the phones actually belong to her. Oh, really? That thinly veiled excuse to rifle through the entirety of 2 of Ms. Reed's cell phones, including all her personal information, is absurd. Trooper Tully argued, expecting this court to take him seriously, that the police and the district attorney need to review the entire contents of Ms. Reed's phones, including whatever personal, private, confidential information lies within, to prove that the cell phones seized from Ms. Reed's possession in Ms. Reed's own home are in fact hers. The same cell phones that Ms. Reed's counsel have demanded be returned to her as the rightful possessor. That the Commonwealth would actually present such an argument as justification to root through her personal data speaks volumes about the true intentions of the prosecutor and investigator behind its motion. Roman 3. As we learned, Roman 3 says the Commonwealth's request is untimely and therefore the information sought cannot be admitted. As we learned recently in Commonwealth v. Diaz, the Commonwealth may not seize a cell phone and indefinitely deprive its owner of their possessory interest before seeking a search warrant. The police may retain an item seized without a warrant for the relatively short period of time needed to obtain a search warrant, but must release the item if a warrant is not obtained within that period. Citing more cases. If the police fail to obtain a search warrant within a reasonable time, the seizure, even if it was reasonable at its inception because it was based upon probable cause, may become unreasonable as a result of its duration. What does the case law say? When officers fail to seek a search warrant, at some point the delay becomes unreasonable. Okay, at what point though? And is actionable under the Fourth Amendment. The Commonwealth bears the burden of demonstrating that the delay was reasonable. The Diaz court held that the individuals have a critical possessory interest in their cell phones. We first note that the defendant had a material possessory interest in his cell phones. Saying many who own a cell phone in effect keep on their person a digital record of nearly every aspect of their lives. Yeah. Massachusetts Appeals Court less than 1 month ago held that a delay of 123 days, there we go. Thank you. There's the money. There's the money shot right there. 123 days between the seizure of a suspect's cell phone and the first time the Commonwealth seeks a warrant to search it is unreasonable. 123 days is unreasonable. And that case was decided less than a month ago. The judge ultimately concluded, based on these findings, that there is no legal precedent for finding a delay of 123 days to be reasonable, even with a compelling governmental interest. That conclusion is to date correct under Massachusetts law. The court further opined that our courts have recognized that some delay in obtaining a search warrant may be reasonable, whereas here the governmental interest in the seized item is critical, but there is no Massachusetts precedent upholding as reasonable anything remotely approaching the 123-day delay in the present case. Here, the MSP seized Ms. Reed's phone on January 24th, 2024, and did not seek a warrant to search its contents until August 28th of 2025. This is a gap of 582 days, nearly 5 times longer than the 123 days that the Diaz court held to be an unreasonably long time. The law is perfectly clear. Commonwealth's request is well beyond untimely, and therefore the evidence sought must be suppressed. Conclusion: Ms. Reed's phones were seized January 24, 24. No action was taken on the allegation of witness intimidation allegations until a year and a half later when the Commonwealth penned this motion. Conveniently, the motion only came to fruition after Ms. Reed requested that her property be returned. Only then did the special prosecutor indicate an intention to rummage through her cell phones in the first instance. The Commonwealth cannot claim that they were merely waiting for Ms. Reed's trial to conclude before pursuing this action because they attempted to indict her before a grand jury while her first trial was pending. For the above reasons and for those argued by defense counsel at the hearing of this motion, Ms. Reed respectfully requests this honorable court deny the Commonwealth's motion and order Ms. Reed's personal property to be returned forthwith. XOXO. Steven Boozang. He's the attorney handling the return of property. Not the same attorney handling the case of O'Keefe's v. Reed. And he filed this September 22nd, and it's just hitting the docket today. Well, you know why? Because it was lost in a black hole. Because I don't even know if there's an index number for this yet or a docket number. Today, for the record, is October 7th. And tomorrow, 2 p.m., there's supposed to be a hearing, and Commonwealth, you've been boozanged. Said Tom Gully. A lot of zingers today. Back to the chat. Hey, it's me. Thanks for your 20. Number 1, narcissist. After 23 years of abuse by a true narcissist, I've learned to be a little selfish. Suck it, Zach. No, thanks for your 20. I'm so sorry that you had to go through that. Tina W says, since you like poetry, read She Asks in Beauty Like the Night by Lord Byron. Thank you. I will look that up. Thank you, Tina, for your super chat. Van Morrison, Into the Mystic is a good song. You're right, Bridget. That is a good song for the vow renewal of our friend Gigi. Mitchell says, I know XOXO is coming, but I laugh every time. Yeah, I didn't get that. Email, Mr. Boozang. Muffin Man says, if the state just admitted that there is evidence on the phone, and this is going back to Walshe and King, yeah? Can the defense submit a motion to the third party the records in? No. Similar to what Anti-Bev denied for the McAllers? No. Because those original Proctor messages were obtained by the feds pursuant to a federal warrant, and they were only turned over to Karen Reed, and they were only supposed to be used in Karen Reed, and now they're trying to expand that order. So I do not think that they would be able to get Proctor's text messages any other way. That is a good question, Muffin Man. Fortunately, I don't think that would fly. Now, what do you think? Because I think this is in front of Judge Krupp tomorrow, right? What do you think? Do you think Judge Krupp is going to understand this motion? Do you think he's going to understand the law? We've seen Judge Krupp a lot, and what we've mostly seen him doing is kicking the can down the road. But we know tomorrow there's supposed to be a motion hearing, and I think it's supposed to be on this motion. Am I right? So what do you think Judge Krupp is going to do? Always a wild card, says Emily C. Mavka says he'll delay. Makazi G is here and says, not a fan. Not a fan. Nope. Cotton Eye Joe by the Rednecks, says David Reese for the vow renewal song. Karen's attorney is Steve Boozang. Al dente, pay attention. Pay attention, Al dente. Steve Boozang is her attorney. And Al dente, I'm just joking with you because you've been with me for over a year. I can see that you have the red velvet cupcake, which is for members over 1 year. And so I love you with all of my heart. But Boozang is the one who, I think we saw him do a message, like a video from his car one time. I don't know why I have that in my head. Like he did an appearance through, on his car, in his car, right? Dina, we saw you in the courtroom. Says, just got home from Dedham. Judge Krupp is awful. Well, he's supposed to hear this motion tomorrow about the seizure, the search warrant for Karen's phones. Be in trouble and 31 is here. Also out there doing the Lord's work with his own money. So they have zero doubt that it'll be resolved tomorrow. Steve-O 24 says, Massachusetts judicial system, we do whatever we want, when we want, and to whom we want. Right? Right? That's okay. Al dente might have just tuned in. So it's Steve Boozang. He's the one who made the motion to get her property back, the Lexus, remember? I think that's where we saw him. Was he like on a news piece maybe? And he was in his car being interviewed by one of the local news channels about the car and why they didn't give it back yet? Anybody? Maybe. Dave Matthews' neighbor says, we at civilians look at it just as we are civilians. I can't imagine looking at Norfolk County through the lens of a true artistic lawyer. I mean, it's been 1 week since you looked at me. I just think it's song. And here she is. Here's Gigi again, gifting 10 memberships because all of you have been giving her such amazing songs. Hold on. Best Dave Matthews songs for weddings. Hold on. For wedding. Steady as we go. That's a good one. Here on out. That's a good one too. I like that one. Let's see. Those are both good choices. I'll back you up. That's a good one too. But I'm only looking at Dave Matthews right now. Dream Girl. That's a good one. Be Kind Tiger says, Vow song, Ambrosia, you're the biggest part of me. At last. Yes, Heidi, no, that's a great one. At last, my love has come along. That's it. That's it, because Gigi said that she gave up on love. And now she's been with this guy for 10 years and she never thought she would find a guy because, you know, so much time has passed. And at last, my love has come along. My lonely days are over. Yeah, that's a great one. I love that. I vote for that one, Gigi. Thank you to all the 10 new members. Cosgrove says, what about Peter Gabriel playing in the dirt? Come on. Makazi G, you're going to get kicked out of the chat today, but we can't kick you out because we like you. Have I told you lately that I love you? Says Scarlet Begonias by Van Morrison. That's good. Gigi, come back. If you stepped away for a little while, come back and read the chat because a lot of people put a lot of good, Etta James, you can't go wrong. True. A lot of good suggestions in the chat here. So thank you very much for gifting 10 memberships to all of the people who suggested your vow renewal songs. That's amazing. I mean, should we take another look at the baby? Should we look at the baby one more time? Should we look at the baby? Look at Good Citizens baby, 5 months old, wearing specially produced for the baby Melanie little merch made by Grandma, Good Citizen. Oh my God, could you just love this baby? Stacy got her shirt. I'm glad you like it. Oh, look at the baby. Look at the baby. You gotta see the baby. All right. I love the baby so much. She's very blessed. Good citizen, you are blessed. When I'm 64 by the Beatles, that's a good one, Pauline. All right. I gotta go take a nap before I get to my Yes concert tonight. So please indulge me. Stay cool, stay kind, stay classy. I love you with all my heart. We're gonna be back tomorrow for the 2:00 hearing on this ridiculous motion to now, search Karen Reed's phones after they've been she had to put the baby down. She had to put the baby down. The baby likes she said the baby falls asleep to my voice. I like that. Maybe not today because I've been yelling too much. Joe Cocker, you are so beautiful. That's a great one, hippie chic. I love it. All right. It's time for Melly to go now. Okay. I love you with all of my heart. If I don't see you soon, I'm going to die, but I'm going to see you tomorrow. So please do all the things that YouTube likes. Smash the like button. Come back tomorrow. Hit the subscribe button because, it's free and it's just a nice thing to do. And, stay away from the internet. Unplug. Go outside. It's beautiful out today. And I'll see you tomorrow. Okay? All right. Peace out, my friends. I love you. Love you, mods. Thank you. I know it was long today. Peace. Bye-bye. Bye-bye.